The so-called judges, those shit in robes who masquerade as guardians of justice while shredding the Constitution, have no legitimate authority to impose any restrictions on the Second Amendment, as its text is unequivocal. The right of the people to keep and bear arms shall not be infringed. This plain language, drafted by the framers to arm citizens against tyranny, crime, and invasion, leaves zero room for judicial meddling or interpretation through fabricated doctrines like public interest or interest balancing tests, which the Supreme Court itself rejected as unconstitutional in New York State Rifle and Pistol Association v. Bruen, decided in 2022. Yet these rogue tyrants, in collusion with a power-hungry government, have systematically dismantled this civil right, one unlawful ruling at a time, violating due process and endangering lives by disarming law-abiding Americans who could otherwise deter criminals, foreign threats, or even a corrupt regime. The government's blanket disarmament schemes, like the federal felon in possession law under 18 U.S.C. Section 922G1, lack any founding-era historical analog for nonviolent offenses. As circuit courts have increasingly recognized, after Bruen and United States v. Rahimi, decided in 2024, where even targeted restrictions require precise historical precedents, not vague safety excuses, that these judges invent to justify their activism. In Range v. Attorney General, a 2023 Third Circuit and Bank decision, reaffirmed after Rahimi remand in 2024, the court struck down the felon ban as applied to a nonviolent offender for minor fraud, exposing the absence of historical basis for such overreach and preempting government claims of categorical authority that fail under strict textual analysis. Similarly, the Sixth Circuit in United States v. Williams, 2024, upheld the law facially but mandated individualized assessments, where defendants can rebut presumptions of danger, rejecting automatic lifetime bans that these shit in robes have rubber-stamped, without due process, aligning with Fifth and 14th Amendment protections against arbitrary deprivations. Critics whine that no right is absolute, citing analogies to free speech limits. But this dodges Bruen's mandate. Restrictions must mirror founding-era laws, disarming only proven threats like violent loyalists, not the broad populace or non-dangerous felons. A point reinforced in ongoing challenges, where courts demand proof of historical dangers comparable to capital offenses. The Fifth Circuit's United States v. Perez-Gallon, reissued December 31, 2024, applied Rahimi narrowly to uphold disarmament for credible domestic threats, but underscored that judges can't expand beyond exact analogs, countering the chaos of circuit splits, where activist courts ignore this to uphold unconstitutional laws. Pending cases like United States v. Himani, with certiorari granted by the Supreme Court in October 2025, further highlight the government's overreach on drug users under Section 922G3, with no historical precedent for such blanket denials, preempting claims that modern policy needs override the text. This judicial government assault has real consequences. By disarming citizens under bogus public interest pretexts, they've inflated crime rates, as studies like John Lott's cross-sectional analysis from 1977 to 1992 show that right-to-carry laws reduce violent crimes like murder and assault by 5 to 8%, without increasing accidents. Defensive gun uses occur at least 61,000 to 65,000 times annually, according to recent National Crime Victimization Survey data from the CDC, often preventing harm, without a shot fired, debunking anti-gun myths of rare or ineffective self-defense that rely on underreported surveys and ignore net benefits. Even Rand Corporation's 2025 findings note inconclusive effects on homicides from concealed carry laws, but underscore why empirical debates can't trump constitutional text as Bruen demands. Though some analyses suggest shall-issue laws may increase total homicides, historical evidence and cross-study reviews affirm overall deterrence benefits that counter such claims. These shit-in-robes aren't protecting the public, they're arming criminals by rendering victims defenseless, all while the government exploits their rulings to consolidate power, betraying the civil rights core of the Second Amendment as a bulwark against oppression. Restore it fully, or watch liberty crumble.